the bill.
I call Moana Mackie.
Thank you, Mr Speaker. I'm happy to take what I think will be a short call on this piece of legislation. And Labor will be supporting the bill to Select Committee. I have to be perfectly honest, I'm not entirely convinced that it's needed, but I do think that there is an issue here that's worthy of investigation. And I think that the particular circumstances of the Tarawera River case provide actually a really good case study where we can have a look and see whether the provisions that are currently in the RMA for the extension of these permits out to 35 years are adequate, whether they do provide enough protection for the communities that are concerned about the health of the rivers or waterways involved. And I do think this is a very good case study because Environment Bay of Plenty, the regional council that issued the consent, is a very, very good regional council. Very good regional council with good relationships right through their community. So it's not like we'd be looking at a case where there are concerns about the quality of decision making in a regional council. This is one where they have a strong reputation. For example, the company Tasman that came and asked for the consent extension asked for 35 years. The regional council said no, 25 years. They put in place a lot of other conditions, including that you couldn't see the discharge in the river, a number of other things. So I think it's actually a really interesting case study as to whether not having any cap or not having a 5-yearly cap or a 10-yearly cap or whatever it might be, whether that is an issue in the law, because this did turn into a very, very messy and emotional issue in the Bay of Plenty. And I want to recognise all the work that Catherine and her partner, Gordon, who was my former teacher at school, did on the particular issue, because certainly, I mean, as we know, looking back through history, environmental practices have varied greatly over time. We've become far more aware now about the impact of a lot of these industrial processes on our environment, and that's why we have laws like the RMA in place now that weren't there a long time ago. But certainly with this particular river, the practices were very distressing for the community. And what I think needs to be put on the record, of course, is that outside of the resource management process, there was a memorandum of understanding that was reached with all the local iwi, not just the iwi that took the court case and failed in that court case, where they actually ended up negotiating a really good outcome. But it took an awful lot of money for the iwi involved. It took an awful lot of pain and anguish getting them there. It was only because of agitation. And now it's not such a big issue because Kawerau are really pleased for the jobs that were created by the extension of that mill and the boiler. And as I said, they've been able to negotiate environmental agreements with Tasman where they work together on the health of the river, and so there's a lot less concern about it in the community now. But the point to that is that's great, but that relies on both the company involved coming on board and deciding that they want to be a partner with the local iwi and the local community, and then being able to negotiate that outcome. And that's not something, of course, that the RMA can deal with. So I think there is a question. This is a very good case study where we could look at where we've had a good outcome, but perhaps where the process and it might not be in every circumstance, and I think there are questions around, because I don't think that a sawmill extending or upgrading its boiler is necessarily an exceptional circumstance. And I think that was one of the key issues, is what this is only meant to be used in really exceptional circumstances. Well, this is the kind of thing that goes on with industry all the time, is that they upgrade, they change, they're going to need to alter the terms of their consent, their discharge consent approval. Is that really an exceptional circumstance? And I think that's where a lot of the debate comes around. So, like I said, I as far as I'm aware, I think this is the only case in which there's been this kind of extension, so probably good time to get in early and before there are any others and have a look at it. Like I said, I think this would be a really simple matter of getting the regional council and some of the stakeholders in to tell their story. It may be that what's needed is a very simple change. It may be that there's no change needed, but I certainly, having gone through in that community and seen the anguish and the money spent on lawyers, wonder whether there's not something that could be done, and certainly think that we deserve to give the iwi of the Eastern Bay of Plenty who went through this the opportunity to come and discuss what happened in this case, to suggest how they might see things working differently. I don't suspect it would take up a lot of committee time. As the members indicated, the government's bringing along some RMA reforms anyway. Maybe it could be worked in alongside that. But I do think actually the committee would benefit from having a look into this case.
Call the Honourable Dr Nick Smith.
Mr Speaker, I want to make a contribution on this bill, make 3 points.